Atta, who is a private legal practitioner, as well as Albert Kwashiga, private legal practitioner and a law lecturer with the UPSA School of Law. Gentlemen, you are welcome.
Thank you, Kweku.
How are you?
Thank you, Kweku.
How have you been?
Oh, it's been okay.
Yeah.
We have been managing.
Yeah.
I mean, given the general conditions, we have been trying our best to survive.
Been seeing you on screen, you know, and again, in and out of court and all of that. Yeah, you seem to be very busy.
Well, I think it's Kelly who has been very busy.
Really?
That's how our bread is battered.
Exactly. I know, right?
That's what we do. Yes.
Well, let's get right into the conversation for today. Justice delivery and court systems. Now, it can seem quite daunting, you know, for the lay person. When you drive past the law courts, you just want to go drive as quickly past as possible. You know, you don't want to be dealing with anybody there. But for the lay person, how would you explain what the court system is, you know, to the layman and justice delivery in general?
Okay, so Kwesi, do I go? Has three key powers.
Okay.
Okay. The state has the legislative power, it has the executive power, and has the judicial power also. And it's the judiciary or the courts that actually exercise the judicial power of the state. And in doing so, a number of processes and people are involved.
Okay.
Very important among these groups of people are the judges and those who work for them. All right. And so it's the expectation that when people have a concern, the legal dispute with another person or even the state, they would use a civilized process or civilized means to resolve the dispute. And so people will usually go to court with their complaint to a judge who would listen to both sides of the matter and then decide, you know, after a process, whose story is more believable, okay, or whose story is most likely to be true given the factual circumstances. And so if you go through the process or the system and you are not really happy, I mean, there are layers of, you know, challenging a decision made by a court.
Okay.
So there's an appellate process that you have to go through and all that. But I must say that the judicial branch does a lot of work, and there are a lot of complex nuances. I'm sure that as we go on, we'll tell you more about it. But basically, that's what. People go to court or go to some or deploy some other means to have their issues settled. And then when I talk about justice delivery, I'm not referring to only the use of the court system. Sometimes there are other ways of resolving the disputes recognized by our law. And that's ADR, you know, which includes a number of things. As we go on, we'll talk about that.
Okay. Okay. Kelly?
Yeah, I was just going to, as he was talking, the words of an English judge just ran through my mind. He says that the courts are like a shrine.
Okay.
And the lawyers, the judges, and the court officials are the ministers in that court. So basically what the court is supposed to do is to deliver justice to persons who have cases before them. As you recall, our Constitution clearly gives the judicial power to the judiciary, to the courts. Half of the people of Ghana. So what happens in the court, either the Supreme Court, the Court of Appeal, or the High Court, justice which is delivered there is supposed to be delivered on behalf of the people of Ghana, from whom the power of the judiciary is supposed to spring from, so to speak. And the courts, the work of the court is are in different levels. So you have the Supreme Court, for instance. I'm sure if you look at the Apex Court, which is the Supreme Court, and then you have the Court of Appeal, and then you have the High Court. And the Constitution is very clear, which is the High Court of Adjudication, which is the Supreme Court. And basically, and I think that the fear about the court, which you expressed early on, is what impoverishes lawyers. So a lot of people don't want to go to court because they're not so sure. And we'll come to talk about lawyers. There are all kinds of things that people say about lawyers. My son, 4-year son, returns from and then the teacher responds, when your father dies, it's going to be buried face down.
I've heard that one.
I mean, so lawyers are friendless. Whatever you say, if you go to the market, you become a minister of the gospel, and they say, that's incongruous.
Yeah.
How can a minister of the gospel
Be a
also be
lawyer?
a lawyer?
Yeah.
Those are some of the difficulties that we face. I think that people need more education to understand what lawyers do, and the fact that the courts are there primarily to dispense justice.
Okay.
Yeah, I have. There's a question that came to mind as you were talking. Have you ever had any experience, or in your studies and so on, experience with the law in Ghana, where a case has traveled from
majority of the cases that go to the Supreme Court have traveled that path.
Oh.
They've traveled from the magistrate court all the way up. Yes.
I mean, they do.
It happens ever so often.
Okay.
It's not easy to tell you why that's the case. It's not very easy to tell why that's the case without sounding, if you like, yes, it's not easy to tell you. But I can say that majority of the cases that are handled by the Supreme Court have traveled from the magistrate court all the way up. So people are not happy with the decision of the magistrate court.
And they go up.
And it used to be the case because you know that for a long time, we had career magistrates, Kweku.
Okay.
We don't have career magistrates anymore. At least the law school is no more training persons to become career magistrates. So those are career magistrates, they are not lawyers, and they are suited to dispense justice in different parts of the country. And because they are not trained lawyers, they are prone to making mistakes sometimes. And when you're not happy, of course, you have to appeal the decision. Perhaps that's what explains why a lot of cases travel all the way from the magistrate court to the Supreme Court.
So let me just add to it. So you find out that, I mean, as Kelly said much earlier, you know, there's a hierarchy system. You know, we have courts, and we have superior courts, and we also have lower courts. I mean, in the past days we referred to as inferior courts, but
sounds pejorative.
So,
Thankfully.
thankfully. So they are now lower courts and they are superior courts. The superior courts actually made up of the Supreme Court, the Court of Appeal, the High Courts, and the regional tribunals. Okay, and then you have the lower courts, which are made up of the circuit court, the district court. Sometimes the district courts sit as juvenile courts, and then you also have the National House of Chiefs, the traditional councils, and then the regional houses of chiefs. These are all lower courts established by the courts, by the Courts Act. Now, each of these courts have their own what we call jurisdiction. I mean, the power to entertain and adjudicate a particular matter. And so you cannot just start a matter which should have been commenced in the Supreme Court in the High Court, for instance. Okay, there are some matters which must go to particular courts. For instance, when it comes to the interpretation of the Constitution of when it comes to human rights matters, you're expected to go to the high courts, for instance. So sometimes the Supreme Court may take some of these matters. You get it. So this is how the court system, you know, is actually working. I think Kelly made the point. Yes, it's actually structured. And so yes, I mean sometimes there are few issues in the system, and I have to say, people have their own views about justice delivery, and I always say that the wheels of justice always grind slowly, but eventually it grinds to a halt. Trust me, because you see, you want to be sure that by the time there's a final determination of a matter, or there's a pronouncement that A is wrong or B is right, the person would have exhausted all the avenues in the court system. So there are all kinds of appellate processes, there are all kinds of interlocutory applications that can be brought. I mean, when the matter is started in the court, a number of things can actually happen. Okay, now there is a very popular case in this country which has now become like one of the key principles when it comes to admission of secretly recorded, evidence. Like the case of Rafael Kubaji versus Asare. The Supreme Court decided it, but that case began from the district court. Okay, and it went as far as all the way to the Supreme Court. So it's just to affirm, your suspicion that most of the cases would have begun from the district courts. And this
now, question then comes in terms of looking at.
Kweku, maybe before
you
ask your next question.
Yeah.
The language of the courts is English. In addition to the language of the court being English, we have, if you like, technical language which is used in the court, legalese, if you like.
Yes.
And I think that a lot of people are not very comfortable with the kind of language which is used in the court. And so a lot of people want to avoid that as much as possible.
Okay.
And if I hire a lawyer, we go to court, and they are saying all of the things they are saying, and I don't even understand. And I don't know the direction to which the case is going. I may just as well not hire a lawyer or go to court at all. I think that over time, this is what has, prevented a lot of people from seeking justice, even in cases where it's very clear.
I mean, I think it's very easy for a layperson speak in court and be understood legally.
Yes,
Well,
and actually, our court processes don't prevent persons to represent themselves in court. But there's an enormous risk.
I think so.
Representing yourself.
I mean, you go and say something.
Yes,
And it may mean something else,
exactly
even
the
though it's
point.
plain English.
That's exactly the point. But
the point is,
actually, nothing preventing persons
from doing that.
who want to go to court. They don't want to use the services of lawyers, and they want to. If you like, represent themselves. Nothing stops them from doing that. But that's at the risk of you losing the case. And
well, that's true. But it's also I think judges who adjudicate on matters where a party is not represented by a lawyer is expected to provide some form of support. Okay. So there are a number of cases which have been determined where people have gone to court without a lawyer, for instance, and the judges have tried to assist them in a way, although it can be a bit cumbersome sometimes. But the judge has a duty. If the judge cannot refer the client to the Legal Aid Commission, or there cannot be a lawyer to take up the matter, and he wants to conduct it himself, then the judge has a duty to ensure that the bar, I'm not saying that to lower the bar a bit when it comes to the procedures, for instance, because I mean, look, the court system has to do with a lot of procedures. Some of them are very technical, and you may lose your case
based on the
technicalities. And our courts have been trying to move away from technical injustice, where people use all kinds of simple technical, arguments to end cases.
to defeat the end of justice.
To defeat the end of justice. So the courts jurisprudence have been to promote substantive justice.
Okay.
Let's look at the merits of the case rather than the many procedural issues. But some procedural issues can be very sensitive, and you can lose your case based on your failure to comply with those.
The lawyers express that by saying, we look at the substance over the form.
Okay.
So that necessary technicality is not allowed to encumber the delivery of justice. Yes.
All right. So, looking at our justice system, would you say that there are things that make it essentially or substantially different from other jurisdictions?
Yeah, I think that the key difference adversarial. And by that I mean that you have two persons who come to court. I'm sure you've seen the scale of justice often.
Yes.
And two persons come to court and they argue their cases out, basically. So we say that it's adversarial in that sense. And this is typical of the common law tradition that many countries or legal systems here practice. And that's opposed to the civil law tradition, for instance, which is as they say, inquisitorial, which is a judge who is largely in charge
charge of
and
the
asking
proceedings.
the questions and things like that, with
Okay.
limited role for
Okay.
the participation of the parties. In other words, the court itself, takes upon
Yeah.
takes upon itself the responsibility of investigation.
Yeah.
As it is opposed to the adversarial system, whereas the parties were bringing the
Coming to
evidence.
argue.
Depending on the quality of your evidence, you're likely to basically win. So I think that that's a key difference, and that difference is on the basis of the fact that we have different countries that belong to
Different
different
traditions.
legal traditions.
Okay, so on the back of what you just said, popular jurisdiction.
Okay.
Yeah, I think the best has the adversarial system, and that's quite misleading. United States of America is a member of the British Commonwealth. Basically, so
And then the
all
civil
of these
law is a
countries,
civil law
civil law
tradition.
countries, you can take that.
All right.
Yes.
Yeah. So I mean, you're talking about the inquisitorial system. Those are the civil law countries
Yeah.
are inquisitorial in their way of justice delivery.
Like who?
So
Because the movies we watch, we always
yeah, but I think
everybody's
that's
adversarial.
Yeah, you watch American. We watch a lot of American movies. But I think most of a lot of these French-speaking countries, for instance, have
Yes.
civil law,
Yes.
tradition, and they are the judge does a lot of the work. It's inquisitorial, and they are more code based, and so all their laws are codified.
Okay.
And the judge takes the lead role in trying to unearth the truth.
Yeah.
I mean of but this we common law get it when lawyers go to court and they are at each other's throats, and they come out of the courtroom and they're having a conversation, and the clients don't see why their lawyer should be talking to the other lawyer. But it's the nature of the system we have is adversarial.
Yeah.
You must try as much as possible to forcefully push your argument, even if you have to dramatize. And everything we do generally in court is about drama. I have to be honest with you.
Oh, yeah.
Because the truth is this: when the parties were going into the agreement, you were not there. You are a third party. They have not told you what went on. Why do you come to court and behave as if you own
you
or
already
you
know.
know?
Yeah.
Really, you don't know.
Yeah.
You are just taking your client's case, believing your client's case to be true,
Yeah.
and pushing it across,
Yeah.
the way
Yeah.
you want it to. I mean, look to the judge or
Yeah.
appealing to the judge. So
Yeah.
basically, that's what we do as lawyers. But it's not like we are doing it. We are doing it to achieve a result.
Yes,
That's what it is.
yes. That's very
Because I
interesting.
don't do drama in court.
Oh,
You don't. You don't.
And I was actually telling him that you can be great. So when we go to court, do not take a laid back position. Be in your element.
Element.
And then when we went to court, he was
Yeah.
in his element.
He delivered.
So when we finished, I told him that Charlie today,
Yeah.
So you asked me to be in my element. So I was in my element. But basically, that's what we do. Generally, that's what we do. But let me talk about
Here.
Meet the new Mrs. Chima.
And I'm not sure say your hospital go be if you hear the female way I get for your dog.
I still have your underwear in my office drawer.
I could never imagine you would end up being my stepmother.
Anybody with the capacity to give you great joy can also bring you insufferable pain.
All right, welcome back. It's still a question of law, and we are discussing very interestingly the justice delivery system in Ghana, our court systems as well. And we're doing some kind of comparisons with other jurisdictions, finding out whether ours is similar or different, and how so. You know, and Albert was about to make a submission before we went on break. Albert,
I was just going to say something about access to the courts. Okay, I mean, how do the courts become seized with a matter to adjudicate on? I mean, there are things we call court. Generally, there are things that you have to file.
okay.
Okay, they are mostly writs. I mean, you file a writ and a statement of claim, depending on the nature of the matter, because there are some matters in which you do not need a writ, you need some other process, okay to begin. You know, so and usually those things, it's lawyers who do them for you, because once you file those processes, there is a process is triggered in the court system. You see, there's this thing about fair hearing, or giving hearing to the other side also. So when, for instance, I commence a matter on behalf of a client in the court, whatever I file, the system is supposed to work in a way as to bring what I have filed to the notice of the other party who I'm bringing a matter against, because he must have the opportunity to file his response to what I'm saying and all that.
So like in a divorce situation, that's what would happen.
That's what would happen.
So a petitioner petitions the court. He says, I want to end it.
I want to end
but
it.
the other person has to be
notified
that this is what, you know. Because
you are brought against me. Then he has to respond in detail.
Has it ever happened where the person has petitioned, but the other one is not aware yet that there's actually been a petition against them?
No, but it's important. I mean, for the petition itself to be given life, for the court itself to begin to adjudicate on it, there ought to be proof of service.
Okay.
So in other words, that petition had to be served on the person on whom it's supposed to be served. In this case, it's going to be the respondent.
Yeah.
The respondent will have to enter appearance and file his response to it.
Okay.
Then the court will begin to look at it. I mean, there are times where it's very difficult. Parties out of the. There are specialized processes.
People deliberately dodge a lot.
We call substituted service.
Okay.
So you make an application to the court. Substitution. You post at a place of your choice, a place which is the petition.
Okay.
It could be an option, or if a person works at a particular place, you go put it there on the notice board, or in his house.
On the gate.
You can go paste it on the gate. So that's service
on the
by
court's
by
notice board,
substitution.
for instance. Yeah.
Just as a footnote to what Albert said earlier about access to justice, I think that we've done very well. A couple of years ago, remember my mentor, Professor Kumado, say that he delivered a lecture on Noah coat of arms.
Yes.
The NAV.